Hello, everyone, and welcome to the Trace to Faster webinar. My name is Alina Kirzner. I'm from Brown Brothers Harriman in Boston with the Global Tax Services Group. I've been with VBH for close to 18 years with primary responsibilities focused on the European markets. I'm a tax attorney by background. I've had the privilege of attending the initial business delegate kickoff meeting that was hosted by the European Commission in Belgium back in October of 2022, and have been involved with and tracking the development of FASTER since then, especially from a custodial industry perspective. With me today, I have Daniele Frescurato, who is an international tax manager with more than 15 years of experience in European and international tax. He has an economics background and is an Italian chartered accountant and certified auditor. He obtained his LLM in international tax law at the University of Austria, Vienna, and his PhD in international tax law at the University of Zurich. After having worked as a tax consultant for 5 years in tax and legal firms, he is now an international tax manager in a multinational financial player based in Italy. Also with us today is Susanne Rauscher. Susanne is a senior business analyst and has been working for Software Dayton Service for over 20 years. SDS provides operational, regulatory, and compliance solutions for the international financial industry. As a member of SDS IREG Regulatory Reporting Squad, she specializes in QI, TRACE, and European Union withholding tax. SDS IREG is a leading standard software for automated global reporting for QI, TRACE, FATCA, and CRS regimes in one single solution. And currently, SDS IREG is working on a German withholding tax reporting solution. Also with us today is Christiane Hölz. Christiane is an attorney, having studied in Germany and in France. She is a managing director at DSW, a leading German investor association with more than 30,000 individual investors as members. At DSW, Christiane is responsible for tax matters relating to investments. She also leads corporate governance research team and is responsible for DSW's participation in legislative procedures regarding German and European regulations, focused on securities regulations, banking, tax, and finance law. Christiane was a member of and vice chair of the EU Commission's Financial Services User Group between 2011 and 2021, and is currently vice chair of ESMA's Securities and Market Stakeholder Group, as well as chair of Better Finance's Legal Committee. So welcome, everyone. So welcome. Clearly on this...
Welcome.
Thank you for having me today.
On this panel, we have representation from various segments of the industry, which should make for a fascinating discussion on FASTER. First, why don't we kick off with just a very brief introduction of FASTER and what it sets out to accomplish. As many of you are already aware, at a high level, FASTER sets out to remove barriers to cross-border investments by making withholding tax procedures in the EU more efficient and harmonized. It also looks to aid in the prevention against tax fraud and abuse. And how does it seek to accomplish this? It does this by proposing via directive a harmonized digital tax resident certificate among EU member states, also a choice between either a quick refund or a leave at source procedure or a combination of both, and of course by standardization of reporting. There are a few elements of the FASTER proposal that the industry as a whole believes are welcome steps in the right direction towards harmonization and simplification. Turning to our panelists, what do you think works in the currently proposed FASTER directive as in its current draft? What are some elements that we feel are steps in the right direction? And then maybe we'll switch sides and think about what needs a little bit more work from the industry's perspective. So turning it over to my colleagues here.
Then I kick off, if I may. Thank you, first of all, to Hansuke for placing this topic as one of the topics in your series of webinars in frame of the conference. you are having in London these days. Thanks a lot, because it's really a topic that goes to the heart of individual investors. As you heard from Alina, I'm a representative of individual investors, and the Commission proposal has really been long awaited by us, because it really can be designed to tackle structural problems and structural obstacles to cross-border investments. The EU Commission wants a single market. The EU Commission wants a capital markets union. One of the biggest obstacles against that is really the withholding tax issue we have at stake. The Commission has done the utmost they could do. They have issued a directive. That's the most they could do in tax matters. And what they did, in my view, has very good elements in it. First of all is the digital tax certificate, which will really speed up processes and harmonize processes. And the second is the quick refund procedure, which will help to accelerate processes significantly. We have seen cases in Italy where investors had to wait 30 years to get a refund of their taxes, of their double paid taxes. This will not happen anymore. So I stop here.
Thank you. And in terms of, go ahead, please, Susanne.
Yes, as a software provider, we of course would like to have a standardized report throughout. What we're witnessing now is a different solution for almost every country. So Finland started off with implementing trace, which was a good step, but other countries unfortunately didn't follow the path of Finland. Yeah. So what we are doing now is we are currently working on the German withholding tax reporting, but it's a solution that is not really in line with the faster directive, because there's different withholding periods, different periods to stick to. For example, there's no the quick refund is not possible in the German, or is not foreseen in the German solution. So, but we've heard signals from the European Communion that there would be, maybe they're still discussing with Germany, so maybe there will be changes either in the German solution or in the faster directive. So we are looking forward, or we are excited what is this year, with what the rest of the year will bring.
Yeah, from my end, I share the view that the ETRC is clearly a step forward with respect to the past, to the extent that the certificate can be ready quickly and can be obtained and shipped quickly, as opposed to the past, where we had like tons of paper coming and going from the tax authorities and to the intermediaries, and I think that that's really appreciated.
Yeah. So yeah, I think the industry is in agreement that the ETRC is probably one of the better steps, better solutions that FASTER has set forth. Of course, I think it's worth mentioning that it is going to be interesting to see how the member states are going to address non-EU member state domiciled investors who are not able to obtain electronic certificates of residence in the same template format verbiage as is required under FASTER. So there is a push out there to ask that the European Commission provide some guidelines for the EU member states as to how to treat non-EU member state investors' documentation. There's also, on the flip side, the situation where you have EU member states investors investing in non-EU member state countries that do not accept electronic certificates of residence. So a solution would be required there too, where they're still able to obtain some form of paper form certificates of residence. And of course, all this can be solved for by each EU member state, but since the purpose of FASTER is harmonization, we are asking the European Commission, as an industry group, we are asking the European Commission to provide at least some form of guidelines as to how to work, what the interplay will be with non-EU member state investors and investments into outside of the EU member states. So I think that's one of the points that still needs to consider in terms of the certificate of residence. And I think we also mentioned that the industry is very appreciative of a harmonized quick refund or relief at source procedure across all EU member states. But I think there's some points that still need to be considered there. And I think, Christiane, you mentioned exemptions for retail. You mentioned retail investors, but could there be some concessions for retail investors in order to have them participate in this regime without being overwhelmed by the requirements?
Yeah, certainly, Alina. If we look back, why do we have the request to now process everything through the intermediaries chain? It's because to get transparency into the whole dividend payments back and forth for member states, to make sure that we don't get any cum-ex transactions anymore. So that's one of the backgrounds: get more transparency into the capital flows. Retail investors, individual investors, they are not part of these money laundering or cum-ex stories at all. So what we are thinking is, why is there a need now for every retail investor to be required to go through the intermediaries chain? Why can't there be an exception for small amounts, for taxpayers that are not prone to money laundering, etc.? So to enable those smaller investors to directly exchange, as they do now, with the tax authorities in another member state, and get a refund without having the burden to go through the intermediaries chain, which always comes, of course, it's a service which always comes at a cost. So that's why we propose, we have proposed to exempt the requirement to go through the intermediaries chain for amounts of up to 5,000 euros per year, for example.
Excellent. That has been submitted as a proposal to the European Commission.
Exactly. And the problem is that the proposal opens up the procedure for the standard procedure for everyone. So everyone could use the standard procedure, but in the proposal itself, there's nothing about the standard procedure at all anymore. It deals with the quick refund, it deals with the relief at source, but it leaves open, mostly open, how to deal with the standard procedure. Can't we improve the standard procedure as well? That would be a big wish from our side.
Definitely harmonization of the standard refund procedure. Yeah.
Yeah, if I may, just building on what Christiane just said, in Article 10 of the draft proposal, there is some room for discretion left to member states to not apply the FASTER framework in the case there is a non-CFI in the chain. And even more worrying is letter B in paragraph 3, which basically allows member state not to apply the FASTER framework in the case where a withholding tax exemption is claimed. And here it is not clear to me why an exemption is considered as a riskier than a quick refund here, because For instance, if we consider the case of investment funds or pension funds or sovereign funds or similar investment structures, they might have issues in their investments, to the extent that they basically claim an exemption based on their status, and if the member states if a given member state opt to not apply the FAST framework in that respect, such structures might have to go back to the previous standard procedures that sit alongside the FAST framework, but this might lead to an inconsistent application of the FAST framework in different member states.
Yeah, Daniele, and also in the current environment, you mentioned that it will lead to two different procedures that are sitting side by side. In the current environment, when, let's say, a pension is allowed an exemption pursuant to a tax treaty, they'll need to provide certain documentation that verifies that they meet all the requirements of the treaty in order to avail of that exemption. And so it's not entirely clear, and I know this is something that the industry groups have also pushed back on for the European Commission. It's not entirely clear, are those requirements going to go away completely, or where there won't be any need to produce all this information that demonstrates their eligibility for the pensions, for example? Or, like you said, Daniele, are those going to be sitting side by side with each other, where you're going to have the faster requirements, and then you're going to have the old regime requirements in order to get to, for example, an exemption under the tax treaty? That wouldn't be entirely harmonized, and probably not something that would be easily supported by the participants in the faster chain. So, yep, please go ahead.
Yeah, and also you have different processes. You have the quick refund, you have the relief at source, and within the 2 days holding period, you have the reclaim process, the ordinary reclaim process, which makes it a little difficult if you have to foresee 3 different processes. So we wish there was a harmonization in this respect. Yeah.
This is also true from an investor perspective, by the way, because we would have wished that the Commission would have required a relief at source procedure, for example, but member states now can choose. And referring to what Daniele has just said about Article 10.3, that for me is also a big, I have a big question mark here, because my understanding is that if one intermediary in the chain chooses not to become a CFI for whatever reason, the whole chain breaks down. And this is not in the remit of the investor, and it's not in the remit of the custodian bank. No one has any influence on this, and then the whole system will not work, which is worrying.
Yeah, right. What is a bit striking to me is that this is left to member states to decide. So that, again, as I was outlining earlier on, this might lead to an inconsistent application of the FAST framework across member states, because if there is any, for instance, I don't know, Swiss bank or UK bank or US intermediary that is in the chain, a certain EU country may apply the framework, another country does not. So you see that this might lead to an inconsistent result.
And we see that with Finnish Trace, they allowed for the concept of a contractual intermediary. So unlike the authorized intermediary that would need to register, which is the requirement of FASTER, there is the possibility of not registering and becoming a contractual intermediary of an authorized intermediary. We don't see that anywhere in FASTER. And I'm wondering whether that's going to have to kind of develop in order to better facilitate the chain where you're, like you said, you're missing a certified intermediary within the chain. So wondering if they're going to have to look to Finland for that one. All right, so we did talk about some of the things that we thought were the better aspects of Trace, of course, of FASTER, of course, with still some issues that need further development. But let's talk a little bit about what we think needs more work in FASTER before it becomes functional. So let's start with the requirement for the investor to declare beneficial ownership. How do we see this requirement shaping out in practice? This is causing quite a big stir among the industry, and just wanted to hear your perspectives on how do we see beneficial ownership shaping out, and what is the European Commission's perspective on beneficial ownership?
I don't know about the EU Commission's position on beneficial ownership. But what I understand is beneficial ownership is defined by member states. So it's incorporated in corporate law. I guess it will be very hard to come up to a common definition. I always said now it could be a good time, and sorry to say that at a British conference, but after the Brexit, now the majority of countries does no longer have the nominee concept, but rather has the beneficial ownership concept, which could finally lead to a common understanding who is the beneficial owner in the end. But I would guess the Commission is reluctant to push forward on this. We've seen this in other pieces of legislation as well, that the Commission is not really keen on going for a harmonized definition in that respect.
Yeah, Christiane, I have the same feeling. The EU institutions do not want to provide a clear definition of beneficial owners, and that might give rise to disputes, as we have seen with respect to the OECD terms, for instance. And going back to my previous example of investment structures through funds, investment funds, pension funds, that might be another concern for them, to the extent that those in the case where the investment is structured through funds, it might be difficult to identify the beneficial owner in that case, because there might be multiple beneficial owners that invest in the funds, but who or at which level should the beneficial ownership be checked and determined? Not to count that such funds in certain countries are not able to get a certificate of residence. So even one of the requirements laid down in the proposal to provide relief cannot even be met in that case. So I see operational issues in that respect.
And providing a little bit of the perspective of a custodian and potentially of an intermediary that would need to register. And I think this would be an investor's perspective too, to be quite honest. But one of the responsibilities, in addition to the electronic certificate of residence, is going to be to obtain an investor self-declaration. So without a standardization of beneficial ownership, which is what the investor self-declaration is going to attest to, we're looking potentially at 27 different documents with 27 different definitions that every investor would need to complete in order to invest in that market. So a little counterintuitive to what we would expected harmonization to be. The concept of harmonization is to reduce the paperwork, to create harmonized documents, maybe one or two harmonized documents that would secure preferential withholding tax rates. But the way this looks right now is potentially 27 different documents with different definitions. Problematic for the intermediaries that need to verify the accuracy of the information on these documents, as well as problematic, I would think, for the investor that needs to worry about various pieces of documents. Having said that, I think we've heard from the Commission where, and I think we're all in agreement on this, beneficial ownership is one of the tougher concepts of international taxation. And I think every country struggles to define it for themselves. It's rooted both in case law as well as in statutory law. And coming up with one definition would be so problematic that 10 years down the road, you'd still be trying to figure out how to implement faster. But having said that, I did hear one interesting comment that was mentioned actually during the European Parliament's discussion on faster, was that, well, can we create a definition, a standardized beneficial ownership definition that will only apply for purposes of faster, for purposes of facilitating the quick refund or relief at source process, and then for purposes of all other legal concepts that require a beneficial ownership concept, that will be left aside, and we only focus on this particular, on how it's defined for faster. So I thought that was an interesting suggestion. I don't know if they'll be able to do anything with that. So outside of beneficial ownership, we know that the industry is also concerned about some of the elements of the due diligence provisions of FASTers. There's concerns that a certified financial intermediary they're asked to verify investor eligibility for preferential withholding tax rates by verifying the electronic certificate of residence and the investor self-declaration that we just discussed. And so the industry is concerned about the requirement for that we need better guidelines, specifically in the area of having to verify whether the beneficial owner is involved in other financial arrangements, not clear what those other financial arrangements are. And not only that, but I think there's a bit of a lack of maybe understanding of what information about the investor's financial arrangements is actually available to the certified financial intermediaries. Usually certified financial intermediaries are not privy to all the financial arrangements that the investor has entered into. So there's definitely the need to recognize the limits of a financial intermediary's visibility of an ultimate investor's activity and understand the scope of the financial transaction issues. So definitely needs a little bit more in terms of better due diligence guidelines. And then it takes us into the area of what happens if there isn't sufficient compliance. So I'm going to open it up to our panelists to comment on that.
Yeah, if I may jump in, I mean, looking at Article 11 of the draft proposal, it seems to me that the guidance related to the due diligence obligations is again left to member states, so that the absence of any common guidance might lead to, again, a different application of such due diligence obligations across member states. And this might, again, lead to an inconsistent application of the whole framework. And I think that the same goes with penalties, because liabilities and penalties, because they are left to member states, so that the implications deriving from non-compliance might be different in each and every member state, applying the directive in its domestic legislation. For instance, one area to me that is tricky and might be sleepy is that of a potential joint liability in the case between, say, investors and intermediaries. So in certain countries, there might be a joint liability between the investor that provides information or does not update the information promptly, and the intermediary that is required to perform the due diligence exercise. And again, this seems to me left to the member state. Again, the lack of any guidance, a central guidance in that respect, might lead to disputes, in my view.
Agreed, Daniele. All right. So I know that the industry has also been lobbying for EU-wide portals for registration, reporting, and the issuance of tax resident certificates. My understanding right now is that each member state, it would be responsible for creating their own kind of portal where an intermediary would be able to register, and then their own portals for reporting flowing through to the relevant tax authorities, and also separate portals for the requests of electronic tax residents. What are you thinking are maybe some of the hurdles with EU-wide portals?
So first of all, I would be.
Yeah.
Go
Sorry,
ahead, Susanne.
No, just what I heard at the conference last week was that they were going initially. The EU Commission was going with a centralized portal, but because of the different jurisdictions, they had problems with taking this idea through. You know, but Christiane, I think you have more information on that. So.
Not necessarily more information, but I have a view. First of all, I have a view. Yeah, I fully agree that the creation of one EU portal would have been much better, much easier, and much less costly. It would be costly for member states to set something up like this. It would be costly for intermediaries to connect with all the 27 different registers, national registers, and these costs eventually will have to be borne by investors. So yeah, we would have very much favored an EU portal, or alternatively, maybe we could think about a passporting regime. We could know this from in the world of funds, for example. So but my understanding as well is indeed, as Susanne said, that the Commission would have liked to introduce something like this, but was not able to get this through. It's more it's taxes. It's in the prerogative of member states. From an investor perspective, the least thing that would be helpful is to have an EU-wide, so to speak, access point. That doesn't help the industry, of course, but if at least we would have an EU access point where we know we can go there and we have all the 27 different national registers, that would be helpful already.
And I think what I've heard is that in terms of the EU-wide registration portal, the concern was that if there is a registered party that needs to be deregistered because they're not in compliance with certain elements of what's required in order to become a registered intermediary. If it was an EU-wide type of portal, then it would require each EU member state to make a decision on deregistration of that intermediary, as opposed to just that one country where the intermediary is registered. They'd be able to make a determination regarding deregistration. So I think that was another concern, is that the process, if every member state was involved in every step of the registration process, then the process for both deregistering and registering could be significantly slowed down, requiring unanimous support among the EU member states for any such actions.
That is a risk, obviously. Yeah, indeed.
The directive proposes a 25-day reporting period that would allow the EU member state tax authorities kind of to, I guess, press a panic button before issuing a refund if they believe the refund may not be appropriate. So the question becomes, is reporting within 25 days practical from an operational perspective? And if it's not, what could be some other solutions in these situations? And one case in point, I guess, is oftentimes we see, I don't want to say often, but we do see failing transactions. And so in instances of failing transactions, there's always the concern that a portion of that transaction would be able to be paid out under the FSTC's quick refund process, but the failing portion would then have to be addressed through the standard reclaim process. And so with a short 25-day reporting kind of turnaround time, you're kind of at risk of having to bifurcate certain payments or transactions between quick refunds and standard reclaims if there isn't enough time or if there's a failing transaction. But what are some issues that we foresee, or maybe we don't, with a 25-day reporting period? And how are some countries going to view a 25-day reporting period when maybe they're used to something more?
So
I would play the you first.
No, you first this time.
I would play the devil's advocate on that question. To be honest, we are in a digitalized world. Normally, I would expect that transactions can be passed on, transferred within the same day. So 25 days from an investor and outside perspective, of course, does not seem to be very short, should leave sufficient time. But of course, I am not inside the industry. I am not part of the intermediaries chain. But yeah, my feeling is 25 days is good.
And as I mentioned earlier, Germany is going with a 45 days period. So this would not be a quick refund possibility in this case. And also the acquisition have to be monitored 1 year before the dividend payment or when the acquisition is occurring. So the periods are quite much longer than FSTC is foreseeing. And but also in case of FSTC, as we mentioned before, we have this 2 days holding period. So this would be an ordinary reclaim process anyway. So it's so there are 2 processes in parallel anyways. So, but for if a transaction is not going through, as I agree with Christiane, I think, yeah, from an investor or software solution provider, maybe from this point of view, maybe we don't see too much issue with 25 days, actually.
I know I've heard that the industry is lobbying for a process, a reporting cycle that would be maybe 15 days the month following the transaction. So allowing for sort of like a monthly, standardized date monthly reporting. And others are asking for, quarterly or something of that sort. These are competing interests. Obviously, the tax authorities would want to, the administrations would definitely want to be able to control the quick refund process, having seen information before they actually allow for the refund. So there's that competing interest, but also the interest of both the processing parties and I suppose the investors, where information is just may not be available in such a quick manner. Although Christiane, point well taken, in this day and age, with all the technological advances, it shouldn't necessarily be an issue. But Susanne, you mentioned Germany. So actually, Germany is in the process, I think, of implementing their modernization act, Withholding Tax Modernization Act, which would go into effect, my understanding is beginning January of 2025. Having seen some of the details of what Germany is proposing, it's quite a robust reporting criteria. And also that applies in the area of vouchers as well that are required in order to file tax reclaims. But the robust reporting criteria to be implemented in 25, and then potentially FASTER's criteria to be implemented in 2027, I believe. I think we're potentially looking at one regime implemented in 25, another in 27 potentially, with no consistency between the reporting requirements or the reporting requirements nor the reporting cycles. I think, Susanne, you mentioned Germany is looking at 45?
Yeah, 45 days after the dividend payment, yes.
So are we potentially looking at Germany changing things later?
Yeah, this is what we are. Yeah, this is what will be interesting in the near future, because as we started already implementing, so we think that Germany either has to decide fast if they still want to like comply more to the FASTER directive, or if they have their own solution. But then this, of course, as Germany is such an important player, so maybe this will make or threaten the FASTER directive, if I may say so. So yeah, this is a very interesting discussion still to come. The EU Commission said they are still in communication with the German tax authorities, and they are cooperative, but they couldn't reveal more than that. So it's interesting what they said. Maybe there's a decision by the end of the year, but nothing is concrete at the moment. So
this must be problematic for your industry, Susanne, where you're working on one set of rules and digital implementation of those, or automation of reporting in those, and then you have a whole other set of rules that may either supersede or
but not only for us, also for our clients. They will implement the software, and then 2 years later they have to change it. So this is really not a good solution, in my opinion, for everyone. It's very costly, and it's very so we are hoping that there will be a solution to that.
Very good. We'll see who wins the battle. So then you mentioned the 2-day holding period quite a few times, and it's important to note that FASTER proposes a 2-day holding period as a security measure against tax fraud. The question becomes, is this 2-day holding period rule a good solution for potential tax fraud? Does it eliminate tax avoidance? It has the potential, of course, of resulting in a dual process where a portion of the claim would be eligible for quick refund, and a portion would need to be filed through a standard refund. It's also, I think, interesting to consider here the interplay between FASTER and the MLI's principal purpose test inclusion, where the PPT, which many countries have implemented into their MLIs, may set forth specific holding period requirements that may not be in alignment with TRACE. So what does that mean? Another level to consider here is consistencies with the MLIs, which so many jurisdictions have recently taken quite a bit of time into crafting, and how the PPT tests will work with the new TRACE regime. So I'm sorry, FASTER regime. So I'm wondering whether the European Commission has taken this into consideration. It's just a thought to put out there in terms of another area that would need to be standardized as to what takes precedence, the MLI or FASTER, and do MLIs now need to be, the PPT provisions of MLIs now need to be revised in order to reflect some of the rules within FASTER. I think it's also the, kind of age-old question of compatibility between treaty and local laws, and who wins in those situations where they're not completely aligned. So that'll be interesting to see how that plays out. So I think up until now, much of our discussion has been in the area of FSTC's impact on financial institutions, also institutional investors. But perhaps we can switch gears a little bit and talk a bit about how the retail investor may be impacted. And Christiane, I know you mentioned this during the initial conversation that we had for this webinar, but maybe we pivot a little bit and talk about how impactful this is to non-financial institution realm.
With great pleasure. As I said, we are very much, first of all, we are very favorable to this proposal. Just two examples. If you are an investor and you have German investor and you have US shares, you just have to have a one-pager, the W8BN form, and you are tax exempt in the US. You have the relief at source procedure. It is done automatically by the intermediaries. We do not have to care at all with that. If I want to get my money back from France, my double tax money back from France, I have to get a declaration from the French bank of the issuer, from the French paying agent, which has to confirm that he has distributed the dividend to me as a German investor. The French paying agent cannot do that because he doesn't know who is the beneficial owner. We talked about the beneficial owner concept. He doesn't know who is the beneficial owner because we have so many intermediaries in between in the chain. So he doesn't give the confirmation. If eventually I get this confirmation, I pay a lot of money for this, up to 100 euros. If you want to claim back 50 euros for dividends, that doesn't make sense at all. So you see, there is really a need to harmonize procedures. There's really a need to standardize procedures. There's really a need for investors to be enabled to reclaim their taxes, also for the small ones, because it's small amount for one person, but it's really going to trillions that taxpayers' money that is not going to be reclaimed because of procedures. We issued a report in that respect earlier this year, where we looked into all the obstacles that are there. So we really need this directive. We need, and we have discussed this, we have to get it right. We need to really standardize, harmonize definitions, harmonize terms, etc., so that we all speak with the same language, and that the processes are really for you guys as intermediaries are really harmonized, so that you can easily process the information between investor and national register. I would stop here. If not, I will talk the rest of the day.
Oh, that's great, Christiane. It's definitely great to hear this perspective, in that the current version of FSTC may not be a one-size-fits-all. There definitely needs to be iterations that would be more applicable to various types of investors. Completely agree, Christiane. It wouldn't be a complete webinar without mentioning blockchain. When I think FSTC just started out, before it was even called FSTC, when it was just an idea, there was some mention of blockchain technology and how that could facilitate in the implementation of a harmonized regime. Maybe at kind of a high level, and I know that not all of us are per se blockchain experts, but maybe at a high level, what are we thinking in terms of how blockchain may be helpful or not in this situation?
Yeah, Alina, I think blockchain could be a step forward in the implementation process of the FSTC framework. For instance, in respect of the ERTRC, based on the supporting documents that the EU Commission published along with the draft text of the directive itself, it seems that the EU already considered blockchain to create a data registry for investors' data. Now, for the time being, they have opted for an easiest solution, which relies on electronic seals with respect to the ETRC. However, they are further investigating whether the blockchain could be used again as a data registry to store investors' data that can be changed quicker than in the current scenario, and can be verified almost instantly, and may provide more certainty with respect to the situation of an investor that might change, for instance, residence during the year. So that we'll see how the analysis will unfold in that respect.
That's interesting. Thank you, Daniele. Definitely interesting to hear blockchain perspective. Especially from a perspective of somebody who doesn't necessarily have the background to understand how it would be integrated into the process. So thank you for that. So just coming full circle, we talked about a lot of different pieces of FASTR and what we think works, what we think needs a lot more work. It looks like there's quite a few provisions of FASTR that need more work, and there's very heavy industry lobbying in that area. But I wanted to kind of bring it together because this webinar is termed called Trace to FASTR. So in the initial stages of discussion about FASTR, the Finnish authorities were significant participants, being the first country to implement a version of Trace. It looks like the European Commission adopted many aspects of the Finnish Trace. Some obvious similarities are the need for the investor to declare investor declaration, where the either authorized intermediary or contractual intermediary would be responsible for verifying beneficial ownership and treaty eligibility. So that sounds very familiar, and it looks like it's repeating itself within FASTR, that element of Trace. But what do we think are some of the more significant differences in this area? So between Finnish FASTR, Finnish Trace and FASTR, excuse me. Those acronyms are getting confused now. What do we think are some of the more significant differences there?
One big difference that I see is that in Trace, the investor information is only passed on to the tax authorities, not up the custody chain, which is, which would be very important in my opinion. And also there are no acquisition costs to be reported, so maybe this has to change in the future. So this is more or less the most different things that I see. Because Trace is also having an XML format report, which is very standardized. So this is a good model for future reports maybe. So, but the XML of FASTR hasn't been published yet. So we cannot see if there are differences, if there are similarities at the moment.
To me, another difference is related to the liability, because according to the implementation package of the Trace proposal, of the Trace framework, an authorized intermediary could be held liable even if it had complied with all the procedures laid down in the implementation package. Now, looking at Article 16 of the FASTR proposal, it seems to me that as long as a CFI complies with the due diligence obligations that are listed in the previous articles, it should not be liable to penalties in that aspect. Liability can arise if the intermediary intentionally or negligently does not comply with the faster provisions. So, I mean, to me, it seems that as long as the CFI complies with such obligations, which clearly, as I pointed out earlier, would require additional guidance, it should not be held liable for any mis-withholding or under-withholding. However, I would like that this conclusion is to be clearly confirmed by the EU institutions, or at least that the EU institutions provide more clarity in respect of the terms intentionally or negligently, in order to get legal certainty about that.
Great, thank you, Daniele. We are coming up on the hour. Did anybody want to say anything else? No. Okay, we are coming up on the hour. I'd like to thank the panelists and Hansuki for organizing this conference, as well as all the participants that had joined. And more importantly, please join us tomorrow at the same time for another webinar on beneficial ownership. Thank you very much. Thank you for joining us. Thank you, panelists, and thank you, Hansuki.
Thank you, Alina.
Bye-bye.
Thank you all.
Thank you for
Bye-bye.
having me. Bye-bye.